First of all, I want to give you an idea of what is the EURODAC database, because I think that most of you are not really familiar with the digitalization of migration control at EU level, and I will give you an idea of what is the historical evolution of the EURODAC regulation from the regulation of 2000 until the Commission proposal of May 2016. And then I'm going to focus on how this repackage of EURODAC under this reform raises serious privacy concerns. And in comparison to other aspects of asylum and refugee law, like detention and right to access to asylum procedure, I understand that privacy concerns are kind of a luxurious ones, and perhaps asylum seekers do not really care about that. But I think that this is an important aspect, because you will see why in my conclusions, because I consider that this is raising serious discrimination issues from that point on. So, in a nutshell, as I told you, EURODAC is a sibling of the Dublin system. It is a digital heart of the European asylum system. It has been a database operational since 2003, and its main purpose was to assist in determining which is the member state responsible for dealing with an asylum application. So that was the original purpose. However, in 2013, there was a new regulation, actually shifting a little bit the purpose of EURODAC, saying that as an ancillary purpose, the EURODAC data, basically the fingerprints of asylum seekers, could be used also for police purposes. So police authorities could have access under specified conditions to fingerprint data. And basically, EURODAC, the premise is that every asylum seeker who wants to apply for asylum in the European Union should be fingerprinted, so a full set of fingerprints are being registered when they apply for an asylum application. This applies to all asylum seekers over the age of 14, and this also applies to irregular migrants when they are apprehended irregularly staying at on EU territory, but their data are only recorded in order to see whether they have applied for asylum, so their data are not stored. However, those who were irregularly found crossing the border of the European Union are also fingerprinted, but their data are stored for a limited retention period, so only for 18 months. So in order to understand, irregular migrants register to see whether they have applied for asylum, their data are not stored. Irregular border crossers, so basically those who haven't applied for asylum but are coming, for example, to Lesbos and Chios, are also fingerprinted, but their data are stored for 18 months, and police authorities do not have access to their data, and asylum seekers' data are being stored for 10 whole years, and police authorities can have access to this data. If we see the package of EURODAC from a privacy perspective, we can basically say that this is definitely not a necessary and disproportionate development of EU law. The interference in itself signifies that everyone who is found, who is undocumented, so irrespective of whether personal situation, they will have to be monitored. This is a serious issue. This is surveillance of movement of irregularly present people or asylum seekers. However, we've seen that immigration control in general is considered as a legitimate aim. And this is member states are being given wide discretion in this respect, so it's very difficult to argue that this is not a legitimate aim. What we can viably argue is that this is certainly not a necessary development, and certainly very disproportionate. It's not a necessary development, first of all, because the purpose for which this is set up, the return, to facilitate the return of regular migrants, I don't see how information in a database can help promote the return. This is because information on EURODAC serves a specific mechanism of allocation of responsibility of asylum seekers. However, there is no similar allocation of responsibility for returning regular migrants. The member state in which someone is irregularly present is responsible for returning this person to its country of origin. I really cannot see how this can be connected unless there is a hidden purpose in there to actually allocate responsibility in this respect in the future, and the Commission is not really saying that this is the case. Also, there is another database that actually stores data of irregularly present people, but these people, there is a high threshold for that. These people have already, there is a national decision saying that these people are irregularly present and they should be returned. And there is an entry ban in their respect in order not to enter the Schengen area again. However, in the case of EURODAC, there is a presumption that these people are irregularly present. This is a serious issue because they do it irrespective of the fact that if they want to apply for asylum at a later stage, irrespective of their personal circumstances, irrespective of whether this can be in violation of the non-refoulement principle. This is completely arbitrary, and it starts from the beginning without any personal assessment of the person. And of course, apart from these necessity concerns, we also have serious proportionality concerns because, let's face it, this is an indiscriminate storage. As I told you, there is no individual assessment of the person. Everyone who is undocumented will be fingerprinted, and the retention period, it's really, the fact that the retention period in other databases is 5 years is really not relevant. You cannot just say, since we have a retention period of 5 years in other databases, then let's align it. This will only serve the purpose of serving the interoperability, the future interoperability. So what the Commission wants to do is really align retention periods and then perhaps create one massive database with every third country national's data, so the rules are pretty much aligned from the beginning. Of course, the addition of facial image, which is biometrics, raises other concerns as well, because not only 10 fingerprints will be stored, but the facial image allows for further processing. It's like a deeper, a second layer of surveillance. It's a deeper surveillance. And of course, future interoperability, we don't know how this is going to play in the future, how this is going to be negotiated, but this is also very problematic. I consider that in the future, all immigration databases will be interconnected. And that leads me to my conclusions. First of all, I didn't have the time to go through other databases, but what we see in the past years is that in times of emergency, of any type of emergency, of security or humanitarian emergency, digitalization of immigration control is the normal reaction, is the natural thing to do. And we see that this is a kind of normalizing the surveillance of movement. Originally, when other databases were being discussed, there were serious concerns, there were serious debates. What we see the past years is that everything happens, let's go digital, let's go electronic, let's monitor everyone, let's put everyone under surveillance. And I consider that after monitoring third country nationals, I think it's time for EU nationals to get scared, because with the EURODAC proposal and another proposal that is also under discussion, basically every third country national under EU law will be monitored in one database, like with the EURODAC proposal, which basically closes every gap of third country national. And I think that we're moving past the privacy concern to a serious discrimination concern, because this will signify that there is a suspicion against third country nationals, so everyone should be monitored irrespective of whether they're coming with documents or without documents, or whether they have serious and valid reasons to be in the European Union. And that's why I consider that the EURODAC is just a huge, ugly duck. So it's not just a small database that's used for administrative purposes. And of course, this is not a hasty policy choice, because as we saw, this was already happening on the ground. People were being fingerprinted before applying for asylum. So de facto, this was already been happening, and now it's just a matter of time to become legal. However, there is another concern, more general in relation to EURODAC, and perhaps this is why the Commission wanted to change EURODAC before Dublin collapses, because if Dublin is definitely not working, why should we have a database monitoring the asylum seeker's fingerprints if there is a suspension of Dublin transfers, the Dublin is clearly not functioning well, and we need to revise it. Of course, this transformation of EURODAC raises serious privacy concerns. There have been a series of judgments in this respect, as I already highlighted a number of issues of concern in this direction. But what we see is that instead of, while the Commission says that we are really committing to the protection of fundamental rights, what we see is that data collection and data storage is actually ever growing. And although they're trying to say that we do it in a proportionate manner, all they do is actually collect more and more data. And this leads me to consider that the EU is definitely not a welcoming region, but actually it's a region that people are excluded and they're actually sorted on basically discriminatory grounds. Thank you so much for your attention. I will now open the floor to everyone.